Good morning, friends. Yashwantrao Chauhan, Maharashtra Open University, B.Com first year, semester 1, book 2, Indian Constitution, Our Rights and Duties में दिए गए राइट टू इक्वलिटी आर्टिकल 14 to 18 के बारे में आज हम विस्तार से पढ़ेंगे. Right to equality, Articles 14 to 18. The right to equality is enshrined in Articles 14 to 18 of the Constitution of India. Through these provisions, social inequalities are sought to be removed, fraternity strengthened, and equality firmly established. The right to equality is considered one of the most important fundamental rights. It is indispensable for the establishment of democracy. Without this right, the other rights lose much of their meaning. The fundamental rights aims to preserve equality in society, thereby strengthening the unity of the nation. Article 14. Equality before law. This article incorporates two principles. First, equality before the law, and second, equal protection of the laws. It ensures that all persons within the territory of India are equal before the law and are entitled to equal protection of the laws. However, certain exceptions apply to the President, Vice President, and the Prime Minister in specific circumstances. Article 15. Prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. According to this article, the state shall not discriminate against any citizen on the grounds of religion, race, caste, sex, or place of birth. It further prohibits restrictions on access to shops, public restaurants, hotels, and places of public entertainment on such grounds. At the same time, the state is empowered to make special provisions for women and children as well as for socially and educationally backward classes, scheduled castes, scheduled tribes, and economically weaker sections. The struggles against gender-based inequality, such as the movement for women's entry into the Shani Shignapur temple in Maharashtra, the Haji Ali Dargah in Mumbai, and the Sabrimala temple in Kerala, reflect the significance of the right to equality. Another important aspect of this right is equality of opportunity, particularly in matters of employment. Accordingly, the Constitution provides for reservations to ensure fair representation of marginalized groups. Educational reservations also flow from Article 15. In January 2019, the Constitution was amended to provide 10% reservation for economically weaker section EWS. This amendment, which introduced reservation on purely economic criteria, was challenged before the Supreme Court on 27th November 2022 by a majority of 3:2 ratio. The Supreme Court upheld the validity of this constitutional amendment. Subsequently, the Society for Rights of Backward Community filed a review petition challenging the judgment. On 9th May 2023, then Chief Justice D.Y. Chandrachud dismissed the review petition, holding that it lacked merit. Thus, reservation based on economic criteria has been judicially upheld as constitutionally valid. Article 16. Equality of opportunities in matters of public employment. This article provides that no discrimination shall be made in public employment on the grounds of religion, race, caste, sex, descent, place of birth, or residence. All citizens shall have equality of opportunity in matters relating to public employment or appointment to any office under the state. However, if adequate representation of backward classes is not available in public services, the state may make special provisions such as reservations. Though reservation has become a subject of debate, it is fundamentally a policy tool aimed at achieving substantive equality. The constitutional basis for reservations in public employment flows directly from Article 16. Article 17. Abolition of Untouchability. Untouchability in any form stands abolished. The practice of untouchability is declared an offence and is punishable under law. The Protection of Civil Rights Act 1955 and the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act 1989 are legislative measures enacted to enforce this constitutional mandate. These laws ensure that the practice of untouchability is treated as a punishable crime, thereby safeguarding human dignity and equality. Article 18. Abolition of Titles. Except the military and academic distinctions, the state shall not confer any titles. The conferment of titles is prohibited as it is inconsistent with the principle of equality. Furthermore, no Indian citizen shall accept any title from a foreign state without the prior consent of the President of India. Similarly, foreign nationals holding offices of profit or trust under the state in India are also barred from accepting titles from foreign states without the consent of the President. Thank you for watching, friends.